So, good morning to all of you. I've been telling you, as per section 47, the execution proceedings. So, the executing court has to decide any points in law or any objections raised by any party. Normally, we are knowing the decree will be given after the judgment, and sometimes it may be transferred to the other court. At that time, if the party, maybe the JDR, normally JDR, if the JDR raises any objections or raises any questions regarding the 3 points execution, discharge, and also satisfaction of the decree, then they shall be determined by the court which is executing. That means the court to which it is transferred. All the points have to be decided, but they should not once again send back the people to the original court which issued the decree. That is section 47. Likewise, order number 21, rule numbers 97 and 103, almost they are similar nature. So, if any resistance or obstruction to the possession of the immovable property according to order 21, rule 97, then the court shall proceed to adjudicate upon the application in accordance with the provisions of the court. That means once again the trial has to be conducted. Then once again the decree should be given as per the law. I will tell you 103. So whenever such orders, the clearance orders are given, they should be treated as decree. So already I told you there will be only one decree, but this order can be taken a fresh decree. So this is the legal position. Now there is a case law in confirmation with these positions regarding section 47. So the Honorable High Court Justice Pratibha M. Singh of Delhi High Court, while disposing the CMA number 21460 by 2020 in the case of Watina Begum versus Shamir Jafar and another on 17/12/2020 held that the executing court normally, even though it cannot go beyond a decree, but it has to answer the questions put by the JDR or the DHR. So this is once again reiterated. Now let us go into the background matter. So here the appellant, she is Watina Begum. So actually she purchased a property in Okhla of New Delhi on 21/6/2012 from GPA holder Dilawar Hussain Malik for a consideration of 9 lakhs. Of course, it was based on, of course, the agreement for sale was also drafted. It was based on a bill, and the GPA, how he got GPA, all the things she has seen, and after seeing the same only, she has got the sale deed executed. Alright, while matters were this, the same persons, so the so-called GPA holder Dilawar Hussain Malik and his wife, they have sold the same property to the respondents here, that is Shamim Jafar and another. They sold the same. Now these people, Shamim Jafar says that he purchased the same property from Dilawar and his wife on 2/7/2012, just after 1 month, not only after 1 month, 15 days. The first transaction took place on 21/6/2012 and this transaction took place on 2/7/2012. So here it is for 6 lakhs. They have given an advance of 3 lakhs and the rest of the amount has to be paid, and this man has given the agreement to sell. But he has not fulfilled his part of registering the place after the repayment of the other 3 lakhs. So matter went to the civil court. So Shamim Jafar and others, they filed a civil suit against the GPA holder Dilawar Malik and his wife, but they were found absconding. Even according to Order 5 Rule 20, the substituted service was also done. It was published in the newspaper Statesman, but they did not appear. Since they did not appear, ex parte decree was given. So to the Shamim Jafar and another, and they filed the EP under Order 21. Now when the EP process was being done, and since these people were the so-called Watina Begum, she was actually in physical possession of that land, of that property. So she raised objection. Whatever it is now, at the time of execution of the decree, the JDR, that is so-called on behalf of the JDR means actually JDR is this man, Dilawar Malik. But the physical position is in Watina Begum. Therefore, she filed an appeal before the Honorable she raised objection before the executing court, stated that she has got all the documents. Therefore, another or a fresh trials to be conducted regarding the position of their documents, and therefore it has to be answered. Now, the court which executed the decree, which has passed the decree, now it has to execute the same. Now the objection has come, but the court rejected the objections and dismissed the same, holding that the agreement of sale, the will, the GPA, all these things are unregistered documents, whereas the documents with Shamim Jafar, they are all registered documents. Therefore, even though trial is done, no settlement, because no settlement issues, because they are totally unregistered documents, whereas the documents of Shamim Jafar, they are registered documents. No useful purpose will be done by once again conducting the trial or adjudicating the matter under Order 21 Rule 97. Therefore, they rejected the petition of the appellant. Moreover, the parties, the DHR party, that is Shamim and Shamim Zafar and others, they have actually filed a petition under RTA Act and came to know that these are actually documents which are forged. Actually, they are forged, and also, yes, they are brought into the purpose only for the litigation, because the document which is purported to have been executed on 21/6/2012, it was purchased in the name of Watina Begum on 10/7/2012. Actually, please remember, the respondents Shamim has got registered on 2/7/2012. Then they have purchased these papers, and actually with antedate they have brought the document into existence only for the purpose of litigation. That is the allegation of Shamim Jafar and others. Now anyway, since the court is satisfied that the documents are unregistered, and also basing on the Supreme Court judgment, that is Suraj Lamps and Industries versus State of Haryana 2011. So when there are no documents, normally no title can be conferred basing upon the unregistered documents. So no trial is required and objections dismissed. Now the matter has come to the High Court. The High Court stated that no doubt the executing court should not go beyond a decree. But according to Section 47, they have to determine the questions in dispute regarding the execution. The basic question is that they have got already an unregistered document. Whether it is registered or unregistered, it is a document. Whether it is a valid document, void document, the court has to decide only after concluding the trial, with the trial. Because the persons, Mr. Malik, Diwakar Malik, or Dilawar Malik and his wife, both of them died, and the property was sold to another person. All this, so much of litigation has done. So if they are present, if Dilawar were present, things would have been otherwise. But when he is absent, he is not allowed. That too, the decree, how the decree was got ex parte. That means purposefully they have avoided attending the court. It is a collusive decree. Therefore, something fishy inside. So to come out with all these things, definitely the adjudication is necessary. Therefore, the Honorable Delhi High Court asked the trial court to conduct inquiry or to try the matter as per Order 21 Rule 97 and adjudicate the same within 6 months. So please remember, this is a good case for section 47 as well as order 21, rule 97. When that comes, order 21 comes, I will tell you. But here, please remember, it's a good case for section 47. The court has to reply, or the court has determined all the questions in issue according to section 47. Good case. Thank you.